Yelmanchilli, Mr. Cruz?
State's ready, Judge.
All right, very good. We are here for a motion hearing. Mr. Yelmanchilli, this is something you wanted to bring up this morning at 8:30. You want to go ahead and preface it for the court while we're here?
Yes, Judge. We are seeking to introduce the testimony of Mr. Larry Peterson as an expert in human and animal hair analysis, really human hair analysis. I believe that the defense has filed a challenge pursuant to 24-7702, or referred to as a Daubert challenge, to Mr. Peterson's ability to present that expert testimony to the jury.
All right, very good, sir. Anything before we get started, Mr. Cruz?
No, Your Honor.
All right, thank you. Mr. Yelmanchilli, you may proceed.
Mr. Peterson, if you would please raise your right hand, sir. Do you swear or affirm testimony you will give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay. If you would, please state and spell your name for the record.
Larry Peterson, Larry-Keithpeterson.
And, sir, will you just pull that microphone towards you a little bit? Thank you. And are you working full-time anymore?
I'm retired. I retired from the GBI laboratory in 2008.
Okay. And I want to go back to your time at the GBI lab. What roles did you serve in while you were at the GBI lab?
Well, I was a microanalyst. That is a person who evaluates different types of trace evidence. So I evaluated hairs and fibers, glass, paint, tape, a lot of other miscellaneous trace materials. So after my training there, I spent about the last 9 years of my employment there as the trace evidence technical leader in charge of supervising proficiency testing and protocols and procedures.
What is proficiency testing?
It's a test that a scientist would take to determine if they're following proper procedures and have the ability to elucidate the correct answer on scientific analysis.
All right. And I want to back up a little bit from there and go back to your educational background. Did you complete an undergraduate degree anywhere?
Yes, I have a Bachelor of Science in Forensic Science from the University of Central Florida in 1977.
Yes, sir. And after graduating from Central Florida and before you started working for the GBI Crime Lab, did you work in forensic sciences anywhere else?
I have not.
Okay. Did you, subsequent to working at the GBI Crime Lab, did you work in forensic sciences anywhere else?
Yes, in 2008, after my retirement, I gained employment with U.S. Army Criminal Investigation Laboratory, where I spent another 9 years evaluating and testing trace evidence.
Okay. Do you have any professional affiliations, or did you previously have professional affiliations before your retirement?
Yes, I was a emeritus and a retired diplomat of the American Board of Criminalistics. I was retired, or am retired status as from the American Academy of Forensic Scientists. I was also a retired member of the American Society of Trace Evidence Examiners and the Southern Association of Forensic Scientists.
Did you ever serve as president of the Southern Association of Forensic Sciences?
I did serve a 2-year sentence, yes.
Have you ever had any studies or articles that have been published?
I have published several articles, I did.
Okay. Have you ever had the opportunity to speak at meetings or conferences related to forensic sciences?
Yes, I have often presented materials and training materials at meetings and conferences between investigators and other scientists.
Okay. And approximately how many times have you spoken at those types of conferences on the issues of forensic sciences?
I don't have an exact number, but dozens of times.
Okay. Have you ever been qualified as an expert?
Yes, I've testified in state and federal and military courts over 400 times.
Okay. And in what areas have you been qualified as an expert?
Areas including mostly hairs and textile fibers and textile materials, glass and wood, chemical unknowns, tape. Probably have lost track of a couple.
Sure. And Your Honor, at this time, I would move to tender Mr. Peterson as an expert in the area of human hair analysis and textile and fiber analysis.
Human hair analysis and textile and fiber analysis?
Yes, Judge.
Mr. Cruz, any objection?
Not to the expert's qualifications, Your Honor.
All right. This witness is deemed an expert in the area of human hair analysis and textile and fiber analysis. You may proceed.
Thank you, Your Honor. As it relates specifically to the field of hair analysis, I want to break down the next portion of our examination into kind of two different categories. One, the science, two, the procedure. So as it relates to hair analysis, do human hairs have unique characteristics?
Human hairs possess a lot of different variable characteristics. The ability to distinguish microscopically one person's hair from another is the basis for having a meaningful association or an elimination from a sample. So it's based on the fact that from a structural standpoint, you know, hairs possess cuticles and protein, the cortex, the middle part of the hair, medullary structures, all of which from a microscopic level are highly variable, but they are not variable to the extent of a absolute personal identification.
Okay.
It could be the possibility that two persons' hair could possess the same characteristics, but is highly variable within the population.
When you say medullary structures, do you mind explaining what a medullary structure is?
Sure. Inside the middle part of the hair, some people have open tubular air-filled gaps inside the middle of the hair. It's not clearly understood why that happens, but it could just be a space-saving biological feature that happens. But and not all people have a medullary structure in their hair. Some people have a lot, some people have a variable amount of a little to a moderate amount, but it adds another important characteristic that's either it's there or not there. It can help distinguish one person from another person's hair.
Okay. And when you say variable characteristics, we've talked about medullary structures. What are some of the other variable characteristics that can be used to determine if a hair is consistent with a known sample or inconsistent with a known sample?
So there are other structures that are observable microscopically. For example, obviously pigment. You have different colorations of pigment and different sizes of pigment. What is the distribution of the pigment within the hair? Is it more towards the outer part, the inner part? Is it clumped? Is it separated particles? There are structures called corticofusi, small little air-filled gaps that can appear in the hair. There's also a material called ovoid bodies, some kind of pigment-related clumps of pigment that can appear in hair. The extent and nature of them and the presence or absence are just other variabilities that help add characteristics that differentiate one person's hair from another.
And as it relates to those variable characteristics, are there some that are more common and some that are less common?
Yes, yes. So it is possible that some characteristics may be more highly distinctive than others. As an example, Caucasian hairs, very fine blonde hairs, would generally not have as many variabilities as a thicker, darkly pigmented hair would have, in general.
And so, I guess, as far as the process that you go through when you are going to conduct an analysis, I want to go to the procedure portion. of hair analysis at this point. When you receive a submission from a law enforcement agency or however it gets to you, how is it that a hair analyst begins the process of analyzing a hair sample against a known sample?
So in the laboratory, we'd either receive a collected hair sample that's already in some type of container identified as collected from a particular location, or it may be a recovery where samples of hair are recovered within the laboratory and then isolated. The hairs are first mounted on a glass microscope slide in a mounting media called per-mount that enables the hair to be observed microscopically. They are looked at under a low-power stereo microscope. Basically, it's a microscope that allows you to see things in more three-dimensional as you would like normally have a vision and see objects, except these are at like around 10 to 40 times magnified. And you can look at the general characteristics of the hair, its length and thickness. So you can start categorizing a hair to potential racial origin, body origin, and just the observation of general features. And that way you can either easily include or exclude a hair for further testing. So hairs are often excluded as being dissimilar at that level. If they are not, they show similar characteristics at that level, they are then transferred to a comparison microscope. So a comparison microscope uses transmitted light, the shine light through the hairs on a side-by-side basis. So there's actually two microscopes side-by-side. Optic bridge allows you to view both of the samples side-by-side. And now you're looking at the internal features, the pigment and the medullary structures if they're present. All of the internal microscopic features are compared from the root, or what we call the proximal end of the hair, side by side all the way to the distal or to the far end of the hair samples. Now, if those characteristics correspond along that way, that enables a conclusion that there is an association, that these hairs are consistent, and they could have originated from that person or another person possessing hair with the identical characteristics.
Okay. And as it relates to, and this is going to be particular to the GBI's processes after an examiner makes a determination that their analysis might have some probative evidence, is there any kind of peer review or confirmation process?
Yes. Any probative associations are reviewed by another qualified examiner, and then there's also a file review that would be done for a review of the notes and the report to see if they, reflect correct procedures were followed and the right significance of note-taking that supports that was also present.
Okay. And to your knowledge, the process that you described, is that the process that is generally accepted and recommended in the scientific community as it relates to hair analysis?
Yes, it is.
When you were working in part as a hair analyst for the GBI, is that the process that you applied when you would conduct hair analysis?
Yes.
Are you familiar with the case of involving a murder that occurred in Athens in January 19th of 2001 with the victim being Miss Tara Baker?
Yes.
All right. And did you have anything that you worked on in that case?
Yeah, yes, I produced several reports of evaluations I did on that case.
Is it related to the hair analysis that you did in that case? Did you follow the procedures that you've just outlined for the court in conducting that analysis?
Yes.
Okay. I'm going to hand you, after I show it to defense counsel, what I have marked as State's Exhibit 136. I'm actually going to go ahead and hand defense counsel 136 through 140. Peterson, I'm going to hand you 136 through 140. Go ahead and take a look at all of them, and then we'll start one by one after that.
Yes.
All right, and so, sir, starting with States Exhibit 136, what is States 136?
Stage 136 is a scientific report which I generated for this case. It follows case number 2001-1002454, which is the crime laboratory case number for the Tara Baker case.
And does this appear to be a true and accurate copy of the report that you generated?
Yes.
And what was the date of the report?
Report is dated February 2nd of 2001.
Judge, I move to tender 136.
Any objection? It is admitted.
States Exhibit 137, what is that?
This is an official report that I generated on February 27th, 2001, regarding some hair examinations, again, under the case number laboratory 2001-1002454.
Does it appear to be a fair and accurate copy of that report that you generated?
Yes.
Judge, I move to tender 137.
Any objection? No objection. It is admitted.
States 138, what is that?
An official report I generated on March 19th, 2001, again, under the case number 2001-1002454, generated, under the Tara Baker case number.
Does that appear to be a fair and accurate copy of the report that you generated in that case?
Yes, it is.
Okay. Judge, I move to tender 138.
Any objection? No, ma'am. It is admitted.
Will you give me the date of that report again?
See, March 19th of 2001.
Thank you, Mr. Peterson. As it relates to States Exhibit 139, can you tell me what that is?
An official report which I generated in May 16th of 2001 on the Tara Baker case, again, case 2001-1002454.
And does that appear to be a true and accurate copy of the report that you generated?
It is.
Judge, I move to tender 139.
Any objection? No objection. It is admitted.
140, what are we looking at there?
140, against an official report which I generated, and this has been October 11th of 2001 under case number 2001-1002454. Again, case generated under the Tara Baker examination.
And does that appear to be a true and accurate copy of your report?
It is.
Move to tender 140, Your Honor.
Any objection? It is admitted.
I'm going to hand you several boxes of slides at this point, and they've all previously been admitted into evidence. So I'm handing you States Exhibits 114 through 122. Defense 31, as well as, I'm sorry, it's States Exhibits 114 through 125, as well as Defense 31. And I'm just going to hand them to you all in this box right here. Okay. And I'm going to give you a few minutes. Obviously, that's a number of exhibits to look through all of those. And you just let me know when you're done with that.
Okay.
Do you recognize those exhibits that I just handed to you?
Yes, these are boxes containing prepared microscope slides with mounted hair samples on them, all generated under the case number for the Tara Baker case 1002454.
And so do those exhibits contain some of the hairs that you analyzed in relation to this case?
Yes, these will be the work product examinations of the hair.
Okay. And, you indicated that they were broken, some of them at least. Were they broken when you were analyzing them?
I'm not sure in the circumstance why any of the slides would have been broken, but, I mean, they are glass slides, so it is possible. And if a slide were to break, it would be remounted. The hair would be removed and remounted.
And I probably asked that question poorly, and I apologize for that. While you were conducting your analysis, was the slide broken while you were trying to analyze? Like, as in while you were looking at it, was the slide broken or not broken?
No, it would have been unbroken.
Okay. And so I want to start with your report in States Exhibit 136. If you could, please explain on February 2nd of 2001, what items were you asked to analyze and what were your findings?
Well, there is a listing for item 2. That is, these are items listed under specifically the case number with a description of the sexual assault collection kit taken from Tara Baker. There were question hairs recovered from the buttocks of the victim, the torso of the victim, the left hand of the victim, and there were also known head hair samples submitted from a Chris Melton, Christopher Hall, Jeff Hall, Ashley Peavy, and Valerie Lang.
Okay. And did you, when you analyzed those hairs, what were your findings as far as any consistencies or inconsistencies, as well as any hairs that may not have been suitable for comparison?
Right, so the examination of the pubic combings of the victim revealed that the hairs present were consistent microscopically with the victim's own hair. The hair from the buttocks, there was one head hair consistent with the victim's own hair. There were 2 hairs inconsistent with the known hair of the victim and several hairs that were unsuitable for comparison. And then additional examination of 2 hairs were associated with the known hair of Ashley Peavy that they revealed corresponding microscopic characteristics. At a later date, then there were 2 hairs, too small for microscopic examination that were later pieced together that could be compared and they were compared at a later report. Hair recovered from the torso. There were numerous head hairs consistent with the victim's own hair. There was 1 hair inconsistent with the victim's hair, which was further associated with the known hair of Valerie Lang.
Then I'm going to stop you right there. So the first set of results we talked about, that's item 8. Is that correct?
That's correct.
And where was item 8 recovered from?
Item 8 was hairs recovered from the victim's buttocks.
Okay. The second set of results that we talked about, item 9, where was item 9 recovered from?
Item 9 was identified as a question hair from the victim's torso.
Okay. As it relates to item 10, which is the next item that I believe we're going to talk about your analysis on, what is item 10?
Item 10 is question hairs identified as from the victim's left hand.
Did you say the victim's left hand?
Correct.
Okay. Were you able to compare item 10 against the known samples that had been provided to you?
Yes. So the results were that there were several head hairs and 1 pubic hair consistent with the victim's own hair.
And so you said consistent with the victim's own hair as far as the hairs in the left hand. Is that correct?
That's correct.
Did you have an opportunity to also compare item 10, the hairs in the victim's left hand, against the hairs? I'm going to start that question over again. Were you also able to compare the hairs in item 10, the hairs that were retrieved from the victim's left hand, to the known head hairs of Chris Melton?
Yes. So once the hairs are associated with the victim, they would have already been demonstrated that the other known hair samples submitted would have dissimilar characteristics.
And so, as it relates specifically to Mr. Melton, what would that finding mean as it relates to item 10?
Well, they could not have originated from him.
Okay. State's Exhibit 137 has already been admitted into evidence. What is the date on that report again?
That would be February 27th of 2001.
Okay. And on that report, did you have occasion to analyze hairs that were recovered from a power transformer?
Yes.
And is that item 12?
Item 12, that's correct.
Okay. What was the result of your analysis on the hairs recovered from the power transformer?
The results are that there were 2 hairs unsuitable for comparison and 1 head hair suitable for comparison. And further examination of the head hair found that it was similar or could have originated from Chris Melton.
Okay. And Mr. Peterson, I don't believe at this time I intend to necessarily introduce any of the fiber or textile evidence, so we'll skip over States 138. As it relates to States 139, what was the date of that report?
That report is dated May 16th of 2001.
Okay. And what were you asked to do in that testing and analysis that you did? Well, actually, I'm sorry, Judge. I misread this report. I don't think that that's going to be information that's going to be admissible based on the court's previous rulings. I'm sorry. That's on me.
Is that something that's already been admitted?
It has been admitted, Your Honor, as far as the report for purposes of the Daubert hearing, but I don't believe that it would be admissible in front of the trial jury.
All right, thank you.
And, Your Honor, I don't believe that the state would be seeking to introduce the evidence that was analyzed in State's Exhibit 1. I think it is something that could be admissible, and the witness has already testified to the fact that he used the same methodology in that analysis, but it does not have any analysis of Mr. Melton's hair associated with it. It was other individuals who were collected as elimination samples and some hairs out of a drain assembly. So I'm not going to ask Mr. Peterson about States 140 at this time.
All right.
Judge, I don't have any other questions for Mr. Peterson at this time.
All right, Mr. Cruz, cross-examination.
Give me a second to put this on.
Counsel, let me, can I see y'all at the bench for just a minute before Mr. Cruz gets started? Let me get your preference. Just a moment, no testimony is going to be taken. Deputy, good morning. Would you please have the jury come in and we'll have them go into the jury room and then we can give them their menus. They can look over that, but we're going to do that for right now. Thank you, because they're here. Good morning, ladies and gentlemen. We're going to give you the menus for today and let you look those over. We'll be with you shortly. Thank you. And Mr. Terrell, do they have the menus for today? Do you have those? Do you have the menus for today for them to look over, or they have them? Okay, very excellent. Okay, very good. Thank you very much. All right, we are back on the record. Mr. Cruz, you have the floor.
Mr. Peterson, good morning. How are you?
Good morning.
My name is Attorney Ahmad Cruz. I have the privilege and honor of representing Mr. Faust. Is it okay if I ask you a couple of questions? Okay. Were you aware, or are you aware, of the United States Department of Justice, the FBI, the Innocence Project, and the National Association of Criminal Defense Lawyers report regarding microscopic hair analysis?
Yes.
Okay. And in that report, you would agree out of 268 microscopic hair analysis testimonies given, 96% of those testimonies were deemed to be erroneous. Is that correct?
I'm aware that the report states that. You know, the other parts of the report is that it's based only on testimony, and a subsequent report to that pointed out that there is no fault indicated in any of the testing, any of the procedural aspects of the comparison of hair, only that there were reports that reflected testimony that seemed to indicate that hair had a absolute or more
Belong to a particular person.
a particular person, as opposed to it, you know, could be other person's hair with the same characteristics. So they felt that during their review that there were strongly worded testimonies that perhaps would have given a false indication of the strength of the hair.
Okay. And would you agree that the determination is that the proper testimony for a microscopic hair analysis would include inclusion, exclusion, or indeterminate?
Yeah, I would say that sounds reasonable.
Okay, that is fair. But the state, from my understanding, is asking you, and correct me if I say anything wrong, to make a personal identification of who certain hair belongs to. Is that right? Is that how you understand your testimony today?
No, the testimony is that the hairs are associated microscopically. So it states that in an inclusion, the hair either originated from that person or another person who possesses hair with the same characteristics.
Okay. And will that be the limits of your testimony here today?
Yes.
That's my question, Your Honor.
Anything else, Mr. Yalman-Chile?
No, Judge.
All right. Anything from the defense?
Just argument.
All right. Mr. Yalman-Chile, you have the opening and closing.
Your Honor, I just reserve.
All right. Mr. Cruz? Well, we've had one. Yes. I don't know where it is. Thank you, Mr. Terrell.
Thank you. You know, I think the case law across the country is pretty clear when it comes to microscopic hair analysis, especially regarding the Department of Justice's report regarding the personal identification of the hair. From what I understand, the testimony from Mr. Peterson is going to be is that, correct me if I say anything wrong, that the hair is still going to be identified as belonging to a particular individual, but just add the caption on the end, or individuals with similar characteristics of hair. Georgia has not addressed this issue specifically, but Georgia has cited cases that have addressed this issue specifically, particularly Crawford v. State, Supreme Court case of Georgia. The site is 278 Georgia 95, and I'm reading from footnote 10. And the site, and it's very important, the site is the most important thing, is CEG, and as the Honorable Court knows, it supports this proposition and example given. Scott v. State is one of the sites. It is 581 SO period 2D 887, and this is page 892 that Crawford is citing. This is a 1991 case that Crawford is citing. Crawford is 2004 to give the Honorable Court the date of that case. But it states, it is important to recognize that hair comparisons do not constitute a basis for positive personal identification. So our argument is to the Honorable Court, the science, we have no issue with the science. It's the conclusions that we have the issue with. The science is solid when it comes to, we have this hair, these are the characteristics of the hair, but as far as saying, hey, this is Mr. John Doe's hair, this is not Mr. John Doe's hair, the science isn't supported in that way. Crawford also states State v. Faircloth, and that's FAIRCLOTH, and that's 99, capital N period, capital C period, APP period, 685. And again, Crawford is a 2004 case, but it's citing a 1990 case from North Carolina. And it states, this is the cite from the North Carolina case. Unlike fingerprints, however, comparative microscopy of hair is not accepted as reliable evidence to positively identify a person. The case also cites State v. Butler, 24 Southwest 3rd, 21. And just to give the Honorable Court the proper information on this case is still good law. It's citing a case from Missouri, still good law, but it was a separate portion of the case was overruled, okay? But this portion is still good law, at least at the time of this case. And what it states is, as the expert acknowledged in her testimony, and as the authoritative articles confirm, there is no scientific basis for testifying that a hair comes from a particular person. Your Honor, I think you've seen this yourself. I think it speaks volumes that the state did not attempt to introduce any articles. We had a Daubert hearing last night with Mr. Chris Bolden, and he at least made sure that he introduced some literature to support the proposition that what Ms. Lycombe was doing was somehow, some way supported by the science. Here, the reason no articles were supported, and of course the state has the burden, is because the articles that are out there, the error rate is as high as 96%, and that was the FBI report that I discussed with the Mr. Thank you, Mr. Peterson. With Mr. Peterson, but also as high as 67%, but on average, as high as 96%, but on average a 67% error rate. So the science, as Mr. Peterson said, is good science. However, you can't take that science and make a conclusion. What it requires is mitochondrial DNA testing that follows up to confirm or exclude. The limitation that I'm asking for Mr. Peterson's testimony, because I'm not saying the science is junk science, I'm just asking that he's not allowed to testify that, hey, this hair belongs to Chris Melton, this hair belongs to Ashley Peavy, this hair belongs to John Doe, or whoever it may be, because the science doesn't support that, the literature doesn't support that, and the state has the burden. And the state hasn't presented anything to support, to show that this process is peer-reviewed. They haven't brought in any evidence about the error rate. The only thing they focused on were the conclusions. And the conclusions in this case, and with microscopic hair analysis, the conclusions that positively identify a person is what's inadmissible, Your Honor. And that is our position. So we would just simply ask the Honorable Court to limit the testimony. We're on the same page as far as the science. The only issue in this Daubert hearing is the conclusions that could be made. We would ask that the conclusion is simply limited to, if you want to describe the characteristics of hair, and say exclusion, exclusion, or indeterminate. We have no issue with that.
Okay, Mr. Cruz, let me make sure I know what you're asking the court to do. So what it sounds like that you are not contesting the state's presentation of the requirements of 702. Is that right?
No. So now in my argument, I'm saying that I don't contest the science, but the state still hasn't met their burden. So I want to make it clear. I'm not saying I agree to admission of this testimony. I'm just saying, as far as argument, I'm not arguing that the science is junk science.
Okay.
But the state hasn't met their burden to admit this argument, so I do want to make that clear.
Okay. All right. Well, that was my question.
Okay.
All right. So the second portion of your argument, though, is inconsistent with the hearing we're having right now. So I guess what I need to understand from you, just so I know what you're talking about, is that you are still contesting this expert's ability to testify in court. And are you also saying that if this witness is allowed to testify, that you want his testimony to be limited?
Correct.
Okay, so you're sort of asking for a motion in limine to some extent. Is that what you're asking for?
If that's the way
Okay.
it comes across, that's fine with me.
Okay, so you're really asking for two different things. You're asking the court to grant your motion with regard to 702. Is that right?
Correct.
Okay. But you're also asking that if the court does not grant your motion, you're asking the court to limit, in a motion in limine, this expert's testimony.
And just to make it clear,
Not say a conclusion as you have articulated.
correct. And we may be saying the same thing, Your Honor, but I understand it as that is a part of 702. It's the testimony that the state is seeking to admit. So I'm saying, my understanding is I'm arguing under 702, the state hasn't met its burden to show the science is good science.
I understand.
Okay. But also, if the Honorable Court says, I disagree, we're asking the Honorable Court to limit the testimony because the state hasn't shown in any manner that the particular testimony that they're seeking to elicit from Dr. Peterson is admissible under 702.
Okay, and that's what I'm calling a motion in limine. But I understand what you're arguing now.
Yes, ma'am.
Thank you.
Thank you, Your Honor.
All right, Mr. Yellman-Chili, any closing?
Yes, Judge. As it relates to the science, am I understanding Mr. Cruz's argument to be that he is not challenging the validity of the science of hair analysis, correct?
I want to make it clear for the record. In closing for our conversation, I'm just advising the Honorable Court that I am not saying it's junk science, but I want to make this clear. I'm not consenting to this testimony. The entire scope of this hearing is for the state to meet its burden. So that's what I wanted the Honorable Court's ruling to focus on, whether or not the state met its burden to if the science should be admitted in this court.
And I'm just asking so that I understand what I need to argue, because obviously if the body of science itself isn't being contested, then I can limit my argument to what I think the testimony was from Mr. Peterson regarding what his opinion would be.
The body of science is being contested to the extent that the state has to meet its burden of proof under 702.
Okay, all right. So, right, all right. I think I understand now. Your Honor, I'm going to hand Mr. Cruz as well as the court a couple of cases, and hopefully I'm not handing anybody my highlighted copy. And Your Honor, can I approach?
You may.
I handed the court two cases. The first case is United States v. Brown. That is 415 F3D 1257. And then the next case is U.S. v. Barnes, which is 481 Federal Appendix 505. Brown is a 2005 11th Circuit case, and Barnes is a 2012 11th Circuit case. And they both stand in general terms for the fact that the court has broad discretion in its ability to review expert opinion evidence and determine whether or not it is admissible under 702, and in particular as it relates to Barnes, which is the 2012 11th Circuit case. If we go to the fourth page on the right side of that opinion, Your Honor, in section E, you will see a discussion of hair and fiber expert testimony that was elicited and admitted in that case. And then if you go forward to page 6 on the bottom of the right side, going into the top of page 7, the case discusses the Daubert factors and makes clear that that is not a those are things for the trial court to consider in its determination, but they're not factors that must all be met in order to allow the admissibility of evidence. The court is still able to exercise its discretion in determining whether or not evidence should be admitted, and that's certainly the case in situations where expert testimony is supported by science and is going to be helpful to the trier of fact in determining an issue, but the scientific field and the methodology used don't allow for quantification, but they are methodologies that are generally accepted within the scientific field. So I think that that touches specifically in Barnes quite explicitly on hair analysis. Again, that's a 2012 11th Circuit case. Obviously, as the court knows, the 11th Circuit is the circuit we look to when we're looking for rulings that can be helpful to Georgia courts when applying standards that have longer been standards in the federal system than they have in the Georgia system, whether that be the rules of evidence or whether it be shifting to the Daubert standard in 24/7/702 for the court's analysis of when to admit expert testimony. And so I think given those factors, as well as Mr. Peterson's testimony about the methodology used being scientifically accepted and his having applied it in his analysis in this particular case, I do believe that the state has met its burden.
That's actually a test Clark County is doing this morning, just so everybody knows we're not under attack, I don't think. I certainly hope not, but that's my understanding. It was 9:30, and I realized that's what it was. So I got an email about it yesterday, and I didn't think about it.
Would you like me to just wait till it's done or just keep going? I'm fine either way.
Let's just wait for a moment because it's just going in and out. So I think you're good. I think you're good.
Thank you, Judge.
Go ahead.
As it relates to the method and, or the, I guess, the form of the opinion that Mr. Peterson would offer, I disagree with defense counsel's characterization of the response that Mr. Peterson offered. I think, in fact, the opinion that Mr. Peterson offered, as well as his response on cross-examination, is that he is not offering an opinion that an individual whose hair is deemed to be, and I'm going to look at the actual language from the opinion, consistent with the known head hair of a sample. It is not to say that that is exclusionary of every other person possible, similar to the way DNA evidence would be exclusionary to, you know, a certain degree of mathematical certainty. In fact, he said the opposite of that, is that his opinion would be that it would be consistent with that individual or another individual who had those same characteristics in their hair. So I think that that is certainly the type of opinion that does not run afoul of some of the propositions that Mr. Cruz has stated to the court, and that his opinion as it relates to hairs that either consistent with the known hair of someone or someone else who has those same characteristics. Now, he said that if there is some opinions in his report that I'm interpreting his response as saying, you know, this hair, this individual can be excluded as a source of this hair because the characteristics are inconsistent, and so we know we can exclude that person. And I think he mentioned some hairs that were not suitable for comparison. I don't know that we elicited any opinions about you know, not being able to form either an inclusive or exclusionary opinion, but certainly there was no testimony, and in fact testimony to the opposite of the idea that hair analysis could yield a, you know, quote unquote match that would be of the type that we would think of when we were thinking about DNA analysis. So I don't think that's the opinion that Mr. Peterson's indicated that he is going to offer, and I believe the opinion that he indicated he's going to offer is an opinion that Mr. Cruz in his argument said would be a valid opinion to offer in the field of hair analysis. So I'd ask the court to allow him to testify consistent with what he has represented his testimony would be in front of the jury. Thank you, Judge.
Thank you. All right, with regard to this particular witness, I've already deemed him an expert in the area of human hair analysis and textile and fiber analysis. I'm making a finding under the requirements for 24-7702 that the state has, in fact, met its burden. With regard to number one, the expert's scientific, technical, or other specialized knowledge will help the trier of fact to understand the evidence or to determine a fact and issue. I think it is clear from the testimony and how Mr. Peterson explained what he analyzes that that testimony is not that which a layperson would know. With regard to number two, the testimony is based upon sufficient facts or data. The testimony was that this expert's analysis was, let's see, conducted, let's see, sorry, I'm confusing my notes here. That his analysis is based upon sufficient facts or data. With regard to number four, this expert has testified that he has reliably applied the principles and methods to the facts of this case. He has testified about the process. He has testified about the manner in which his analysis is reviewed, how that is consistent with his tenure at the GBI, that it is accepted in the scientific community, that his methodology is scientific, and that he also used the processes that he described in analyzing the evidence in this particular case. And so I believe, based on the evidence that the state has presented through Mr. Peterson, that they have met their burden under Daubert. With regard to the motion in limine, the reason that I'm going to deny your motion, Mr. Cruz, is because it is not necessary. It is clear that this expert is not going to testify in the manner that you're asking for him not to. That his testimony is one of either consistency or elimination, but his testimony has not indicated that he is commenting on his analysis in the way that you were asking the court to exclude it. And so I'm just making a recognition of that. I don't think it is necessary. Should it become necessary, I'll have a hearing outside the presence of the jury and we'll discuss it. But that certainly has not been the case in the hearing this morning. So I'm going to deny your motion with regard to 702 and this particular witness. All right. Is there anything we need to take up? We're going to take a quick break and then bring the jury out. Ask the state first. Anything we need to talk about before we get started?
No, Judge.
All right. Mr. Cruz, anything, sir?
No, Your Honor.
All right. Very good. We are going to take a 5-minute recess and then we'll bring the jury in. Thank you.
Just for disclosure, I just located a witness that we had previously tried to find. He wasn't included on our witness list because I couldn't find any good information for him. But I bumped into him into the courthouse, and I'm assuming the state have an objection to it. But we're going to amend our witness list tonight, provide state notice of his information. I just got his information. Which would allow us to bring him in during our case in chief. But I do think because it's in the middle of trial and it's kind of the last minute, it's something that does need to be brought to the attention of the Honorable Court, just so the Honorable Court to decide if this is something the Honorable Court would allow or not allow, and that would determine our preparations.
All right. Thank you. Mr. Yellow-Mitchell.
I guess one of the first questions would be, who is it? And as far as a determination for the court, what would this person testify to? I don't know that not having contact information is grounds for not including somebody on a witness list. If it's newly discovered information, that's a separate thing. But before the state takes a position, I just would need some more information as well.
All right. At this point, I'm not going to allow another witness on the witness list. The witness lists have been out for a long time. They have been subject to amendment before we began this trial. If it was somebody that either side knew that they wanted to testify, even if they couldn't find them, that person needed to be included. The jury, the entire jury pool, but particularly the jury that has been seated, they were all asked questions about whether they were related by blood or by marriage to all of the witnesses in this case. And that would not have been done for this particular edition. And so I'm not going to allow it. All right. Anything else before we bring the jury in?
I just would like to get a sense of the court's preference. Our next witness is going to be Ms. Lacan, who testified last night. Right. Certain exhibits were admitted during that Daubert hearing last night. It would be the